Greetings at Cheating Story Workshop. The forensic examiner's report, a sound permanently etched in my memory, had an understated finality as it landed on the judge's desk. My wife's lawyer momentarily paused mid-speech, his gestures still hung in the air from some dramatic argument about emotional manipulation. Opposite him, Veronica fixed her gaze on the manila envelope, as if it held evidence of a crime scene. Indeed, it did. "Your Honor," my lawyer stated serenely, "we'd like to present Exhibit 12 for the court's review." Inside that folder lay 73 pages of analysis, each page offering proof that every word my wife had sworn under oath for the past 40 minutes was a deliberate falsehood. Yet, I find myself recounting events out of sequence. My name is Malcolm Reeves. Approximately 11 months ago, I was a 42-year-old software architect with a wife I'd cherished since college, a daughter embarking on her sophomore year at Northwestern, and a life constructed over 20 years, stone by meticulously placed stone. Currently, I am a divorced individual who discovered that the person sharing your bed can be an unknown entity. This is how I verified it. Veronica and I crossed paths in 2003 at a conference in Austin. She was concluding her MBA studies, while I was 3 years into constructing a data security consulting firm. We tied the knot in 2005, and our daughter Kelsey joined us in 2006. For 19 years, I thought we were partners in every aspect, financially, emotionally, and strategically planning our future together. The prenuptial agreement was Veronica's idea. Let me emphasize this point because it's crucial. She suggested we safeguard our individual assets before marriage. Her father, Arthur Langston, was a real estate developer who experienced the devastation of divorce when Veronica was 14, watching her mother's attorney dismantle everything he had built. "I never wanted either of us to be in such a vulnerable position," she told me during a weekend in Sedona, 6 months before our wedding. "Let's be prudent about this. Protect what we each bring in, share what we build together." We decided to handle our upcoming marriage in a grown-up, practical manner, so we each retained legal representation. My uncle suggested Ellen Kasami, a family law expert, for me, while Veronica chose Bradford Haynes from a firm her father utilized for business contracts. Over a span of 3 months, we hashed out the terms of our prenuptial agreement. I have time-stamped and saved emails as proof of Veronica's active involvement in every alteration. She was keen on clauses safeguarding her anticipated inheritance, insisted on language regarding her future business endeavors being separate property, and even asked for specific provisions concerning any potential intellectual property I might develop. The final agreement spanned 16 pages. We signed it at Haynes' office with both lawyers present, 8 days before our wedding, with Veronica reading every word aloud before affixing her signature. I remember this occasion particularly well because she paused on page 9 to request an explanation of the difference between commingled and separate accounts. He explained it to her twice. She penned a note in the margin, inquired about the limit for shared savings with M, then endorsed the modification. I had not contemplated our prenuptial agreement again until last January. Veronica filed for divorce on the 18th of that month. There was no prior warning, no discussion about issues. When I returned home from a client meeting in Denver, her lawyer's notice of service was stuck to our front door. She had left while I was traveling, taking Kelsey's childhood belongings, photo albums, and oddly enough my grandfather's watch that was kept in my nightstand drawer. Her petition sought half of everything. The house, my company, my retirement funds, even the Tesla I bought with a government contract bonus, she had no role in. The reasoning was California's community property law, despite our prenuptial agreement clearly specifying that my business and any assets related to it were separate property. That evening, I phoned Ellen Kasami. She informed me they were contesting the prenup after reviewing the filing. In high-value divorce cases, this one is particularly aggressive. The claim is that you coerced her into signing under duress. Even if they can't prove emotional manipulation, financial pressure, or lack of genuine consent, such tactics can invalidate the entire agreement. Her filing alleges that you threatened to cancel the wedding if she didn't sign, that you isolated her from family during negotiations, and that she was young and intimidated. I was taken aback by every word of that. We will prove it's a lie, but Malcolm, this could get messy. Such accusations often escalate into character attacks. Are you prepared for that? Initially, I wasn't, but I had no other choice. The first deposition took place in March. In a Century City conference room, Veronica, who seemed like a stranger, sat facing me with a demeanor suggesting a victim. Radford Haynes guided her testimony, much like a conductor. "Miss Langston," he asked, "could you explain your emotional state prior to your wedding?" With a quiet voice, she responded, terrified. Veronica continued. "Malcolm had grown controlling, managing our financial decisions. He'd already put down a payment on the house we were to live in under his name alone. The prenup terms gave me concerns, but he threatened that his family wouldn't attend our wedding if I didn't sign. He called me paranoid and ungrateful." Our eyes met, yet she avoided mine completely. "Did you feel like you had a choice?" Haynes inquired. "No," Veronica replied. "I loved him. My parents spent thousands on the venue, 200 guests RSVP'd, and I merely wanted to please everyone, so I signed documents I didn't comprehend." Ellen leaned closer. "You did have your own lawyer during the signing, didn't you?" "I encountered him on 2 occasions. Malcolm was the one who selected him, a colleague from his uncle's law firm. I felt awkward challenging anything in front of them." "Radford Haynes is now your attorney," Ellen mentioned, "but in 2005 you hired him yourself for the prenuptial agreement discussions. Are you saying you can't recall that?" For a brief moment, Veronica's composure faltered. "I remember meeting with someone my father suggested, but Malcolm was always in control of the conversation. I was 24 years old and didn't fully understand what I was signing. The lie was so well rehearsed that it struck me as premeditated. It appeared that she had been crafting this narrative for months, if not years, rewriting history to portray herself as a victim of circumstances she had in fact controlled." Ellen pushed an email across the table towards you. "This is an email you sent to Mr. 2005-0712. In your message you stated, 'Bradford, based on our conversation, I'd like to incorporate language safeguarding my future income from any self-initiated creative ventures, while ensuring the same autonomy for my own business as Malcolm enjoys. This point should be addressed in Section 7. Does that seem reasonable to you?' In response to the suggestion that your client may have been unaware of legal complexities, it was objected that this lack of understanding does not disprove emotional coercion. Your client argues she was a passive observer, but Ellen challenges this claim. This email demonstrates proactive negotiation and strategic decision-making. As Veronica read the emails presented by Ellen, her jaw tightened. She stated she took these measures to safeguard herself as she was aware of Malcolm's manipulative nature. These emails also reveal Veronica's persistent pursuit of clarifications and adjustments regarding terms and proposals. By the conclusion of the testimony, Haynes altered his approach, claiming that Veronica was compelled to agree to the prenup to prevent disputes, and her compliance indicated coercion rather than consent. They intended to manipulate the narrative. Any evidence I had, they planned to reinterpret as indicative of my control, which is when I ceased playing defense. I engaged Adrian Yu 3 days later. Adrian is a forensic document examiner who has testified in over 200 civil cases involving questioned documents, forgery, and handwriting analysis. Ellen utilized her in a contested will case 5 years ago. If there are any physical indications on that prenup contradicting Veronica's account, Ellen said, Adrian will identify them. I provided Adrian with everything: the original signed prenup, all email correspondence, drafts with revision marks, and even the notepads from meetings where Veronica and I had taken notes together. Examine every page, I instructed her. Every sign, every initial, every notation. I require evidence if my wife handled this document. I need confirmation. What are you aiming to uncover? Adrian inquired. The truth. She's asserting she signed this under compulsion without comprehending it. I'm aware she made edits herself. I need you to substantiate that. Adrian's report took 6 weeks and cost $18,000. It was worth every penny. The trial commenced in early September, with Judge Patricia Morehouse presiding over Family Court Division 7. The courtroom was smaller than anticipated, featuring wood paneling, fluorescent lights, a subtle scent of coffee and paper. Veronica sat with Haynes and 2 paralegals at the plaintiff's table. I sat with Ellen and Junior Associate Patel, along with an unopened folder. Haynes summoned Veronica to the stand initially. She wore a gray dress, minimal makeup, and reading glasses she seemingly didn't need. The presentation was impeccable. I encountered Malcolm when I was 24, she testified. He was more mature, successful, self-assured. I revered him. During our engagement, I believed I had found a companion, but his controlling behavior changed the dynamic. He took charge of where we lived, how we managed finances, and planned our wedding without much input from me. When he presented the prenuptial agreement, it felt like an ultimatum: sign it or risk losing everything we had planned together. Haynes inquired, Have you consulted with a lawyer? I did meet with someone, but Malcolm was present at every meeting, interrupting my questions and explaining things in a way that made me feel foolish for not immediately understanding. As the signing approached, I felt overwhelmed. I just wanted it to be over. I signed because of my love for him and fear of losing him. Judge Morehouse took notice, her previous silence giving way to leaning forward slightly. Veronica's story was emotional, convincing. Ellen cross-examined diligently, presenting emails and meeting notes as evidence. Records from Haynes' 2005 timesheets indicate Veronica had 17 consultations with him without my presence, spanning over 3 months. However, Haynes had previously set up his case, as every piece of evidence he presented suggested Veronica was defending herself within a controlling situation. She attended these sessions because she was compelled to, Haynes noted during cross-examination. Not because she acted out of free will. We took a break for lunch. Ellen cornered me in the corridor. "We need the forensic report immediately," she said. "Our story makes it appear as though her involvement was due to pressure rather than choice. We require evidence that proves she wasn't just participating, but actively agreed to this arrangement. Will Adrian's analysis hold up? It will if it reveals what you expect, but be aware if the report is indecisive, we've merely squandered our strongest piece of evidence." I flipped through the folder for the first time, consisting of 73 pages. Enlarged images of handwriting specimens, spectral evaluation of ink components, comparison diagrams exhibiting letter construction, pressure imprints, stroke progressions. Page 47 was emphasized in yellow. 11 instances of handwritten notes in document, a titled prenuptial agreement, were verified via comparable matching to be written by Veronica Langston. Annotations included date alterations, pages 29, clause changes, pages 714, numerical revisions, page 11, and margin explanations clarifying purpose, pages 36913. Chemical analysis suggested the annotations were inked. Over 3 distinct sessions based on chemical differences, I scrutinized Ellen. "Let's proceed." When court resumed, Ellen summoned Adrian Yu to testify. Adrian was 56, with gray hair unassuming. She donned a navy suit and carried a leather portfolio containing magnified photos of the prenup's pages. Judge Morehouse leaned back as Adrian took the oath. "Doctor," he began. Ellen said, "Dr. Yu, could you elaborate on your qualifications for the court?" Adrian detailed her academic background, Ph.D. in forensic sciences from UC Davis, and professional experience, 28 years as a certified document examiner, along with her membership in the American Society of Question Document Examiners. Her expertise was not contested. In various federal and state courts across 12 jurisdictions, her testimony has been accepted. Haynes likely believed she would merely verify signatures, a routine task that wouldn't challenge Veronica's claim of duress. However, he underestimated this. Ellen then asked, "Dr. Yu, you analyzed the prenuptial agreement signed by Mr. Reeves and Ms. Langston in August 2005. What did your analysis reveal?" Adrian pulled out her portfolio to respond. Was the author of these annotations Veronica Langston? After analyzing the annotations against examples provided by both parties, including signatures from the prenup, emails, personal notes, and other documents, there was a 98.7% statistical certainty that it was her handwriting. The courtroom fell silent as Ellen displayed a photograph on the overhead projector, page 9 of the prenup, enlarged to poster size. In the margin, neat blue ink contained an inscription. "Ask M about joint savings threshold. Want min $50 case separate before commingling. Can you explain this note?" Ellen inquired. This note indicates financial clarification, specifically concerning thresholds for separating individual and joint accounts. Adrian responded, explaining the content demonstrated an understanding of the legal concept of commingling and strategic planning regarding account structuring. The handwriting matched Ms. Langston's. Ellen proceeded to present 6 more pages. Each annotation bore similar modifications, dates adjusted from August 10 to August 18, a provision regarding intellectual property with C. Bradford's memo note, patent protections in the margins, and a comment beside the spousal support waiver that said, "Confirmed W. Dad, this safeguards my inheritance if M's business fails." Dr. Yu, how many independent drafting occasions do these annotations signify? Based on ink analysis, at least 3 distinct sessions are discernible. The blue ballpoint ink on pages 2, 6, and 9 shares identical chemical indicators. The black felt tip ink on pages 7 and 14 shows differences. The pencil marks on page 11, later traced over in pen, represent a third session where the writer was making adjustments prior to finalization. Ellen faced Veronica. Therefore, it appears that Ms. Langston not only signed this prenup, but also edited, annotated, and revised it across multiple revisions. This statement is accurate. Haynes stood up abruptly. Objection, Your Honor. The presence of handwriting doesn't invalidate Ms. Langston's signing of the prenup. Dr. Yu, the note indicates that the writer exhibited strategic, legally minded thinking, understanding that business income could lead to potential liabilities and desiring explicit protection from such risks. This suggests advanced estate planning awareness, not someone blindly signing documents without understanding them. Regarding your query, with my 28 years of experience in examining documents for disputed legal matters, do you think this prenuptial agreement indicates it was signed under duress or coercion? Adrian replied decisively, No. Instead, it demonstrates active and informed strategic engagement by both parties over an extended negotiation phase. Upon hearing this, Ellen took a seat. No more questions. Approaching the stand cautiously, Bradford Haynes seemed to be wading through fog. It was clear he had misjudged the forensic evidence. However, he pressed on. Dr. Yu, you stated that Ms. Langston's handwriting is present on this prenup. Yet isn't handwriting analysis somewhat subjective? Adrian conceded. It can be. That's why I employed various verification methods: visual comparison, computerized stroke analysis, and chemical composition testing. The results were congruent across all techniques, but I cannot testify about Ms. Langston's handwriting in court. It's plausible that Langston was under emotional distress or pressure when making these annotations, but the nature of the notes suggests otherwise. In normal circumstances, writing under severe duress would exhibit signs of stress, such as erratic pressure, inconsistent letter formation, and indications of haste. However, Ms. Langston's annotations show a meticulous, analytical style that contradicts this assumption. You raised 3 separate writing sessions. It was proposed if these occurred under persistent coercion. Ellen objected, stating it called for speculation beyond the witness's area of expertise. Haynes then approached the subject differently. Dr. Yu, in your analysis of documents from 2005, did you consider the possibility of long-term duress? Is it not feasible that the analysis is inconclusive due to the age of the documents? No, the documents were well preserved, and analyzing aged documents is routine in my field. In fact, the ink and paper become simpler to examine as their chemical compositions solidify over time. Haynes acknowledged he was losing ground. He hastily concluded his argument, attempting to minimize damage, but the damage was already done. Veronica's testimony regarding her passive, intimidated role as a bride who signed papers she did not comprehend now conflicts with physical evidence that she cannot rationalize. Judge Morehouse requested closing arguments. Haynes presented first. He had adjusted his strategy one final time. Now he was asserting that the handwriting analysis, while intriguing, did not tackle the broader pattern of Malcolm Reeves as a domineering partner who established an atmosphere where Veronica felt compelled to engage with the prenup or face repercussions. Veronica was attempting to navigate a dire circumstance as shown by her annotations, asserted Haynes. She participated due to the lack of alternatives provided by Mr. Reeves. The prenup isn't invalid because she didn't physically touch the pen. It's invalid because she touched it under duress, fearing the consequences of refusal. A tactful maneuver was employed, but it disregarded all that Adrian testified concerning the annotation's content. Ellen concluded her argument succinctly. Your Honor, we've been presented with a narrative today about a woman coerced into signing a document she didn't comprehend. The forensic evidence contradicts this account. Ms. Langston didn't merely sign this prenup. She drafted parts of it, negotiated its terms, clarified its meaning with her attorney, and made strategic decisions regarding the safeguarding of her own assets. 19 years later, Ms. Langston's argument isn't based on duress, but rather buyer's remorse. The courtroom was hushed, save for the faint sound of an air conditioner humming overhead. Veronica, looking downcast at the table, had her friends fidgeting with papers. I maintained a calm demeanor, hands folded in my lap, watching Judge Morehouse intently. After a lengthy pause, the judge looked up. Ms. Langston, over the course of my 16-year career, I've dealt with genuine duress claims, situations where one party was truly unable to consent due to threats, coercion, or mental incapacity. This case doesn't fit that description. Veronica paled upon hearing this. The evidence presented by doctor in question was deemed irrelevant. Yu's involvement in drafting the prenuptial agreement is evident, not merely a signature on a document. Your handwritten annotations exhibit legal knowledge and strategic thinking. They reference discussions with your attorney and illustrate an understanding of complex financial concepts like commingling and liability protection. Crucially, they suggest foresight regarding how this agreement would safeguard you in diverse situations, even those involving potential risks to your inheritance arising from Mr. Reeves' business. Judge Morehouse examined the photograph of page 14, focusing on the note about liability protection. This annotation alone undermines your entire testimony. You are not a passive signatory unaware of the contents. Instead, you are an active participant securing your interests. The motion to invalidate the prenuptial agreement is rejected. As written, it will dictate the division of assets in this divorce. Mr. Reeves' business. Reeves' individual business, retirement savings, and assets directly linked to his separate property remain exempt from community property division, as per the prenuptial agreement stipulations. The trial will continue for the remaining disputed assets, but the prenup stands valid and enforceable. The judge hammered once. Court is adjourned. A trial date for the remaining property disagreements will be established within 30 days. Veronica departed the courtroom without glancing at me. Haynes was already on his phone, likely phoning to share this development with her father. Ellen gathered her briefcase composedly, suggesting she had anticipated this result. "You performed well," she remarked as we walked towards the elevator. "Many would have caved under a duress claim. You relied on the facts." "I relied on the truth," I replied. The divorce was finalized 8 weeks later. Veronica abandoned her claims to the business and accepted a $400,000 settlement in accordance with the prenuptial agreement, which she had personally negotiated in 2005, adjusted for inflation. She retained the Pasadena house we purchased jointly, half of our combined savings, and her entire inheritance following Arthur's death 3 years prior. I maintained control over my business, my retirement funds, and the Tesla. Kelsey remained impartial throughout the ordeal. Currently, she is 23, a graduate working in renewable energy policy in Portland. She revealed to me months after the trial that she had long suspected something was amiss with her mother's account of events. "Mom is adept at rewriting history," Kelsey noted. "I'm grateful you had evidence that prevented her from altering the truth. I often ponder over that prenup, not the paper itself, but its significance, Veronica's notion, her plan, her safeguard. She was astute enough to demand it 20 years ago because she grasped risk. At some point, she determined that the risk she had shielded herself from was no longer practical. Thus, she deceived. She manipulated our shared past to portray herself as a casualty of circumstances she had orchestrated. However, there was something she hadn't foreseen. The truth doesn't discriminate. It doesn't consider the persuasiveness of your tale or the sympathy you evoke. The truth resides in forensic evidence, handwriting samples, and notes penned in blue ink on a warm afternoon in 2005. The thud of that manila folder on the judge's bench was the sound of the truth arriving. Final, undeniable, indisputable, and that's a noise I'll never forget.